Welcome to Time is Not on Your Side with your host, board-certified business litigation attorney, Robert Eckard. In every episode, you'll hear insights from Rob and those he trusts to impact the success of your litigation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now, here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to podcast season number 2. Time is not on your side. I'm Robert Eckard, board certified business litigation attorney and government investigation specialist. Season 2 of Time Not on Your Side will focus on providing substantive content on various legal topics such as business litigation, international law, understanding contract disputes, intellectual property, and securities issues. Today's topic is 10 international treaties every lawyer should know. Now, we all hear terms such as global economy, international rights, and international law, but what does all that mean? Now, having received my LLM in international law and business and having practiced international law in some capacity for 25 years and presented on podcasts, performed seminars for the United States State Department and other international business and criminal transaction and handling international child abduction cases, there's treaties that lawyers should know about in order to understand how the law operates. Now, a treaty is a formal and binding written agreement entered into by state actors on international law. It's synonymous with other international agreements such as protocol, covenants, conventions, trade agreements, peace agreements on human rights, and others. And they're set to establish international standards by the parties involved. Treaties can be bilateral, meaning between two parties, or multilateral, between multiple parties. And some treaties are governed by the Vienna Convention, and international agreements between states are governed by international law. Now, in many countries, treaties have a higher status than domestic law and must be incorporated into domestic law before they can take effect. In others, like the United States, treaties have the same status as federal law. The 10 treaties of most relevance, in my opinion, and not in any particular order for attorneys to know, are: number 1, the United Nations Convention on the Recognition in Foreign Judgment and Arbitral Acts. This is an international treaty that aims to facilitate enforcement of foreign judgments and arbitrations. Now, it's adopted in over 160 countries worldwide. It establishes a regime that promotes the finality and enforcement of arbitral awards, ensuing that they are recognized and given consistent manner of application amongst jurisdiction. Now, under the treaty, they're binding and enforceable on countries that have ratified the convention. And it sets out the groundwork for the recognition of such arbitral awards and the application, including those in violation of public policy. This treaty also provides for a mechanism for simplified enforcement of arbitral awards. Now, it can be enforced in the same manner as a domestic court judgment. For lawyers and businesses involved in international commercial arbitration, understanding this convention and familiarity allows lawyers to enforce arbitral awards throughout international jurisdictions and ensure the protection of their clients. Treaty number 2 is the Hague Convention on the Civil Aspects of International Child Abduction, commonly known as the Hague Convention. This aims to protect children from the harmful effects of international abduction by one parent or the other, where children have been wrongfully removed from their country of residence. Now, the Hague Convention on International Child Abduction was adopted in 1990 and has been adopted by over 100 countries. Under the convention, a child is considered to be wrongfully removed or retained in an unlawful jurisdiction when one parent breaches the custodial rights of the other parent and that child's home country. The convention establishes a central authority in each participating country, which is responsible for facilitating the return of the abducted children through the central authority to that home country. The Hague Convention on International Parental Abduction also recognizes the importance of ensuring the protection and well-being of children during the return process. It encourages cooperation between the countries in taking the safety and security in the child's best interest at stake. For lawyers and individuals dealing with this convention, it's critically important with familiarity of this convention to advise their clients of their rights and legal obligations and procedures towards the resolution of the best interest of the child. The third treaty is the Warsaw Convention. It takes effect almost every time you travel internationally on an aircraft. And this is an international treaty that governs the ability of airlines and the rights and passengers of international travel. It was adopted in 1929. The Warsaw Convention establishes a set of rules and limitations regarding death, injury, loss, or any type of damages that may arise in compensation to passengers and shippers in an international accident. Now, the Warsaw Convention is generally a strict liability crime. It's also known as the Montreal Convention, and it's periodically adjusted to consider other factors to allow airlines and other carriers to litigate for issues of negligence. The Warsaw Convention establishes procedural requirements to bring in claims against airlines, the timing of file suits, jurisdiction, and the legal framework for international air travel, passengers, and shippers that allow for compensation in the event of injury. The Montreal Convention, which is also a name for this convention, provides for the application of this convention that even have not ratified this convention. And so for lawyers involved in international travel or accidents or damages occurring through the use of international carriers, familiarity with this convention is vital important in case of accidents or losses during international air travel. The Hague Convention 4, the Hague Convention on the service of abroad of judicial and extrajudicial documents in civil and commercial matters, known as the Hague Service Convention, provides a framework of service of legal documents across international borders and allows for extrajudicial documents in countries that are party to this convention. This convention was adopted in 1965, and over 70 countries have ratified the Hague Service Convention. Under this convention, the central authority of each contracting state is responsible for receiving and transmitting requests for service of documents to the appropriate authorities and the receiving state. The central authority acts as a central point contact for the transmission of documents and facilitates communications between parties and receiving parties. This convention sets out specific methods for the service of documents, including personal service by email, judicial officers, and those to complete certificates of service. It aims to ensure the service of documents is carried out in a manner that's prompt, reliable, and efficient, and it promotes certainty and due process in establishing standardized procedures across borders. For U.S. lawyers, this is also crucial when dealing with international litigation or cross-border disputes, and familiarity with this convention to serve legal documents in foreign jurisdiction and the procedural requirements that are required. The fifth treatise of import is the Hague Convention on the Recognition and Enforcement of Foreign Judgments, which is an international treaty that helps promote and facilitate the enforcement of commercial foreign judgments across borders. The Hague Convention on Recognition and Enforcement of Foreign Judgments was adopted in 2019. And March 2nd, 2022, the United States ratified the Convention on the Enforcement of Foreign Judgments. It is designed to streamline and simplify the process of enforcing foreign judgments, reducing the need for lengthy and costly legal proceedings in multiple jurisdictions. Now, under this convention, a judgment rendered in one participating jurisdiction can enforce the judgment of another jurisdiction without going through substantial obstacles. It seeks to enhance access to justice, facilitate trade, investment, encouraging the free flow of judgments across borders. It provides for clear, predictable outcomes with commercial judgments and when enforced with contracting states. It applies to civil and commercial matters, including certain types of disputes such as bankruptcy, intellectual property rights. It requires the recognition of the foreign judgment and it be conclusive, not contrary to public policy. At the present, there is no U.S. law that governs the recognition of foreign judgments in the United States. Rather, enforcement is by state law that are relatively consistent throughout states in the District of Columbia. And most of those are modeled after the National Conference of Commissioners on Uniform State Laws. We also use the Uniform Foreign Country Money Judgment Recognition Act, also known as the 2005 Uniform Act. This treaty represents a significant development law and provides for harmonized framework for the recognition and enforcement of foreign judgments. For U.S. lawyers understanding the Hague Convention on the Recognition and Enforcement of Foreign Judgments, it's crucial, especially for clients involved in international business transactions or disputes. And familiarity with this convention allows lawyers to advise their clients on enforceability of foreign judgments and navigate the complexities across cross-border litigation. The sixth treatise is the Hague Convention on the international obtaining evidence abroad. This is for gathering and the presentation of evidence in civil and commercial matters across borders. The convention aims to simplify and streamline the process of obtaining evidence from one country to the other in the use of legal proceedings, such as documents, witness statements, and expert opinions from foreign jurisdiction. It also sets forth the rules regarding authentication and admissibility of evidence throughout these procedures. It's a set of standardized procedures and requirements. The Evidence Convention promotes international judicial cooperation to help ensure evidence can be fairly obtained and effectively used across borders. The seventh treatise is the United States-Mexico-Canada Agreement. This is an agreement that replaced NAFTA and came into effect July 1st of 2020. And it was negotiated to modernize the relationship between the three countries. The five key objectives of this treaty are market access, which aims to enhance market access for goods among the three countries. Digital trade. This provision is to address digital trade, e-commerce, across border data flows, and establishes rules to protect digital trade to ensure the free flow of data across borders. 3, intellectual property rights. This treaty protects international property rights by establishing higher standards for copy, trademark, and other intellectual properties, such as regulating counterfeit goods. 4, this treaty also promotes labor rights and environmental protection standards, including minimum wages, workplace safety, and the right to collective bargaining, and to combat illegal wildfire trade. And 5, dispute resolution. It includes a dispute resolution mechanism between the member countries and establishes panels to hear disputes on the interpretation and agreement between the parties. Now, it has wide implications, including for agriculture, manufacturing, intellectual property, and it creates a more level playing field for businesses in the three countries. Now, this treaty was negotiated over a period of several years between Mexico, Canada, and the United States before it came into effect, and it helps significant trade involving economic landscapes between the parties. The 8th convention, or the treatise, is the Refugee Convention, which is one of the international covenants on political rights and is an important international treaty on human rights. This was formally adopted in 1951 as the status of the International Refugees Convention, and it was promulgated after World War II for individuals in the legal framework of their status of their treatment. This treaty, the Refugee Convention, defines a refugee as someone outside their country or nationality who has a well-founded fear of political prosecution based upon race, religion, or other national origin, and our fear of being returned to their country where their life or freedom would be at risk. And it allows them to provide legal status in the country in which they're seeking refuge. It was ratified by 149 countries, making it one of the most widely accepted treaties internationally. The ninth treatise, is the International Covenant on the Civil and Political Rights of Peoples. This treaty is a comprehensive human rights treaty that focused on civil and political rights. It was adopted by the United General Assembly in 1976 and is used to recognize a wide range of civil and political rights, including the right to life, liberty, and security of person, freedom of expression, freedom of religion, the right to fair trial, and the prohibition of torture, cruel and inhumane punishment. It guarantees the right to participate in public affairs, the right to privacy, and the right to freedom of assembly, similar to our First Amendment rights here in the United States. Countries are required to implement this treaty consistent with domestic law. It's been ratified by 173 countries, making it one of the most used human rights treaties internationally. The 10th treaty is the Vienna Convention on Consular Relations. This convention on consular relations establishes that obligations for consular officers for nationals in the event of arrest or detention. The Vienna Convention on Consular Relations is treaty number 10. This convention establishes obligations for consular officers worldwide. Article 36 is particularly relevant because it allows a detained foreign national to communicate with the consular office of their home country when they're detained. Article 36 is important because it sets forth the rights and obligations of the detaining authority and detained national, and it requires the detaining authority to inform the host country of this detained person and allow for them to have access to the consulate office without delay. Now, while this is not a complete and exhaustive list of the treaties we've discussed today, an awareness of these treaties and conventions should assist any attorney person facing legal issues to start with this list as a beginning starting point. for U.S. lawyers understanding and well-versed in international treaties is essential to allow and navigate complex international transactions and deal with evolving cases of international law, cross-border disputes, and rights of individuals. The 10 treaties discussed represent a fraction of the numerous international agreements that shape the legal landscape. By being well-versed in these treaties, U.S. lawyers can navigate complex border legal issues, protect human rights, promote international cooperation, and the equitable global system. Now, today we have a special guest, Peyton Cochran, who's a first-year associate here at the law office of Robert Eckard. We have a special guest here today, Peyton Cochran, who's a first-year associate at the law office of Robert Eckard and Associates in Palm Harbor, Florida. Hi, Peyton.
Hi, Rob.
Peyton, who has some experience dealing with international legal matters, which kind of always can bump into international criminal matters, is going to share her thoughts on the application and the interpretation of the treaties we've discovered, one in particular, the International Refugee Convention. So Peyton, what is your perspective on that convention?
So to start out with, I'm happy that you did this podcast on 10 international treaties that all lawyers should know. But I think the topic's a little more expansive than that. I think there's a lot of important international humanitarian right issues that are raised by some of these conventions, especially the Refugee Convention of 1951, that need to be known by everyone, lawyer or regular layperson. And that's something I would like to talk about.
So the Refugee Convention, tell the listeners what that convention is, what it is intended to do, its application, who qualifies for it, some of the things that people might want to learn, especially considering these immigration issues, especially now coming to the forefront here in the United States.
Yeah, so I think it's interesting first to understand the world that existed when the Refugee Convention was entered. As you mentioned earlier in your podcast, the Refugee Convention was entered into in 1951 following the creation of the League of Nations and following World War II. Now, this was a time when all the countries on the global stage saw the effects of the world wars and wanted an end to it. So it was a big time of international cooperation. Unfortunately, what we've seen today, it's a bit of a different world where it's very big on state sovereignty. And that's the overriding issue that I see with not only the Refugee Convention, but a lot of the international treaties is with the rise of state sovereignty and obviously issues with geopolitics, there's less enforcement.
So what you're saying is based upon the historical ebbs and flows of political parties throughout not only the United States, but throughout the world, what you're, I think, describing is this inherent tension between the application of international treaties such as the Refugee Convention and a country's sovereignty concerns and issues in maintaining that sovereignty and security.
Yes. And when I discuss geopolitics, I do definitely mean state sovereignty, but there's also issues of racism, xenophobia, just people. As an example, in the world, there's about 118 million refugees or displaced people at this current moment in time. In most of today's news, you hear about the Ukrainian crisis and the Russian crisis, and most of the refugees taken in by European nations are Ukrainian refugees. But what people, I think, don't hear enough about is in Sudan, there's been a civil war going on for many years, and Sudan actually has the greatest displacement of people across the world. It's the greatest displacement of people in history. And there are approximately 18 million people displaced in Sudan, which is roughly 16% of the population on its own. And these refugees are being taken in by neighboring countries or Sudan itself, where the quality of life isn't much better. So I think even though you have the Refugee Convention, which codifies a lot of the standards that are supposed to be imposed when treating refugees and dealing with refugees, but in real life, they don't get carried out because of all of these other issues that need to be addressed in society. And
including that inherent tension, right, between the state wanting to maintain its sovereignty and not have to capitulate, if you will, to this convention for the sake of the convention.
And we saw that in, I believe, 2020 or sometime around there when Germany was the first to say, we don't want any more refugees, we're not taking them in. So it's not like this is like a hush topic, countries are coming out and saying, we don't want to take any more refugees. And isn't that inherently against what the Refugee Convention is supposed to stand for? And
correct me if I'm wrong, but it seems to me that part of the problem has been the vetting of refugees or refugee status, and simply identifying someone as a refugee that may qualify for the protections under this convention with a contracting state could be an issue that needs to be vetted at the sovereignty of that state to ensure that this person that's seeking asylum or status as a refugee under the convention truly fits that criteria and is not simply coming across, let's say, the southern border of the United States and is from a country that we identify maybe as a terrorist country or an adversarial country.
Yeah, I'm glad you mentioned that, because I think that also plays a role into international law. And when I speak about it's a different world today than it was when all of these treaties were originally entered into, it stays the same no matter which treaty you're really talking about. If you look at international law in a whole, it's very idealistic, very rarely actually enforced, because there aren't good enforcement mechanisms, there aren't good vetting measures, and there's not a real good way to balance a state's concern with its own sovereignty versus the ideal and the good of the whole. So it's until a bigger conversation is had, nothing is going to get solved when it comes to these conventions.
They're aspirations, right?
Yeah.
It's not like we have like here in the United States, a domestic body of state courts and federal courts that interpret and essentially enforce the laws that our Congress or legislature enact. And the enforcement of those laws, like international treaties, are carried out by the judiciary here in this country, and in fact, necessarily enforced by law enforcement, the executive branch. And that doesn't really happen at the international level.
And it's interesting that you mentioned that, because I'm not sure how much, again, this is why I think this is something that more than lawyers should understand, is when it comes to international realm, there's really two bodies of lawmaking. There's the International Court of Justice and the International Criminal Court. The International Court of Justice is really enforcing treaties between countries. It's not going after individual citizens. And the International Criminal Court is going after individuals like leaders of states or leaders of terrorist organizations. But it's also very rarely enforced, and it's not ratified by many countries, including the United States. So the enforcement mechanism is completely lacking.
It's almost, I hate to say, a voluntary submission, which it is, which the United States has not ratified or recognized the International Criminal Court. But that was one of the tribunals that I believe was responsible for the oversight and the eventual prosecution of Saddam Hussein.
Mm-hmm.
So the willingness of a state country to adopt and ratify a convention and therefore submit itself to the potential jurisdiction of that oversight tribunal is another subject for another day, but also creates some problems for the enforcement of these treaties.
Yeah, I think, I could go on for this forever.
Do you have any last thoughts on international law or international treaties before we wrap up?
I hope that international law, because I truly believe it is such an interesting body of law, and it is very interesting to see, especially the humanitarian rights portion of it, which I find very interesting and moving. I hope that more people, whether or not you see this or you read about it somewhere, take some time to understand the intricacies, because in international law with domestic law, not everything is really as it seems.
And I know you've had some experience early on in your legal career, hands-on with international parental and child abduction cases under the Hague Convention, and the impact that convention has had in the returning of wrongfully taken children from their host country by one parent to another, and then return to their country. So you've seen how this works, and that it can work.
We have, and we got photos back from the dad once he reunited with his children, which was really sweet to see. So it does have great impacts. And I think the Hague Convention especially is one of those that has enforcement mechanisms. And it's a well-written body of law. So it does work. I'm not trying to be a pessimist, but there are issues as well.
Well, thanks, Peyton, for your insight today, and we appreciate that. This concludes another episode of Time Is Not On Your Side. Be sure to watch our episodes and like us on YouTube or any other social media platforms. Until next time.
You've been tuning into Time Is Not On Your Side with your host, board-certified business litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others. The views expressed on this program are not necessarily the views of Robert Eckard and Associates, its attorneys, or guests. Any videos or other content presented on Robert Eckard and Associates' website or other social media platforms is for educational purposes only. All content presented is for educational purposes only and shall not be construed as providing legal advice or an endorsement of any third party or such third party's views, nor any private company or government agency that a speaker may be employed or affiliated with, or as a solicitation or offer to sell securities or provide investment, tax, legal, or consulting services, and shall not be relied on nor acted upon without obtaining specific advice from a qualified professional. We believe the information presented to be reliable, but is not guaranteed as to its accuracy or completeness. All examples are hypothetical and for illustrative purposes only. Any opinions or statements by Robert Eckard and Associates, PA employees, guests, or other third parties are their own and may not be representative of the experience of others or indicative of future performance or success. No compensation has been exchanged for any testimonials, endorsements, and/or recognitions. Past performance is not a guarantee of future results. No attorney-client relationship is established with the law office of Robert Eckard and Associates, PA Law, until such time as a duly executed retainer is signed by you and an authorized agent of law, and any retainer deposit paid and returned to us.